Hello and welcome everyone. I am Lawrence Wu. I am an economist and president at NERA Economic Consulting. Thank you for joining us today. We have a really fun hour for you today, and you will hear from three interesting and knowledgeable people who are experts on a topic that is evolving very quickly and at the heart of so much debate these days. The topic, of course, is the legal, economic, and regulatory intersection of two very important policy agendas: competition policy and data protection policy. I'll introduce our panelists in the order you will hear from them. Tom Reynolds will kick us off. Tom is head of economics at the UK's Information Commissioner's Office, or ICO. Thanks for being here, Tom. We'll then hear from Tanya van den Brande. Tanya is Director of Economics at Ofcom, which is the Office of Communications in the UK. And we also have on the panel Jerry Pachina, who will be our third speaker. Jerry is a QC at Moncton Chambers and ranked as a leading silk in many areas, including competition law and data protection. Tanya and Jerry, thanks for joining the panel also. It's been really fun to chat with them, and I hope you enjoy hearing from them also. Tom, let's start with you. The ICO and the CMA recently published a joint statement that begins by saying that there are strong synergies between the interests of data protection and competition. Why don't you start? What are those synergies?
Thanks very much, Lawrence, for that introduction and also for the invitation to speak this afternoon. Yeah, so as you mentioned, back in May, the ICO and the CMA, the UK Competition and Markets Authority, published a joint statement setting out our shared views on the relationship between competition and data protection in the digital economy. And I think a simple starting point for thinking about synergies between the data protection and the competition regimes is the observation that, at the highest level, both of these regimes ultimately aim to benefit consumers, whether it's by protecting data and privacy interests or by promoting competition to the benefit of consumers. And the joint statement explains that policy can be designed to support both of these objectives, and it points to three sets of synergies in particular. So firstly, there's the importance of user choice and control, of meaningful user choice and control. And this is a foundation of data protection and privacy law. So for example, where personal data is being processed using consent as the lawful basis, that consent needs to be freely given, specific, informed, and an unequivocal indication of the user's wishes. And equally, in competition, well, that's best served by having informed and empowered consumers making genuine choices about services or products. So clear synergy there. Secondly, there's the role of clear regulation and standards, which can protect consumers and ensure a level playing field between businesses. So well-designed regulation and standards that preserve privacy and user control of data also serve to promote effective competition and to enhance privacy, perhaps driving innovation such as the development of privacy-enhancing technologies, for example. And it can also help build trust in the digital economy, which is important for the adoption of new technologies and economic participation more generally. And then thirdly, given the crucial role of data, often personal data, in the digital economy, data-related interventions are also an important consideration. So amongst them, responsible data sharing is a measure that allows both the exercise of data protection rights and can also foster competition by facilitating consumer switching, overcoming barriers to entry, and so on. So yeah, a number of ways there in which the regimes complement each other and have real synergies.
That's a good description of the synergies, and I can see the alignment but as I read the ICO CMA joint statement, I also got the sense that the statement also made clear that there are circumstances where the policy objectives of protecting personal data while also promoting competition might not always be aligned. So what are the tensions and trade-offs?
Yeah, absolutely. So while we stress the strong synergies, it's also important to recognise that the objectives might not always be aligned. And the joint statement calls out two examples in particular. So firstly, and picking up again on the data access intervention example, one possibility that was outlined in the CMA's 2020 market study into online platforms and digital advertising was about providing third parties with access to data. So you can see, well, on the one hand, that could promote competition, create efficiencies to the benefit of society. But on the other hand, it could also lead to more widespread processing of personal data and by a larger number of controllers as well, so raising data protection risks. So a potential tension there, but one that we think could be managed by designing and implementing policies in compliance with data protection, as for example set out in the ICO's data sharing code of practice. And then the second area, a bit more complicated, is where there's risk of data protection requirements being interpreted in such a way as to lead to negative competition outcomes. So, the interpretation of data protection law, perhaps in ways that that favour large integrated digital businesses over smaller non-integrated suppliers. So the example here, just to flesh things out, is the interpretation of data protection law in which transfers of personal data between different businesses owned by a single corporate entity, a large platform company, for example, that's viewed as acceptable from a privacy perspective, while transfers of data between independently owned businesses are not, even if the circumstances are sort of otherwise equivalent. And on this latter point, the statement explains that neither competition nor data protection regulation allows for a sort of simple sort of rule of thumb where one's okay and the other's not. Under both regimes, you need to look carefully at the circumstances, case-by-case assessment and applying the relevant law.
But Tom, given that you mentioned synergies and you mentioned some tensions in the goals, so how do you think it's going to manifest itself in a practical way? I know the agencies are cooperating, but practically, what's going to happen next?
Yeah, of course. So while we've been clear that there are these strong synergies and it's possible to design potential regulatory interventions to further both of these policy objectives, and then, as I say, the way to resolve any residual or potential tensions is then through careful consideration on a case-by-case basis and through exactly the sort of close regulatory cooperation that the joint statement illustrates and also lays the foundations for in the future. And it's not just the joint statement as well. Closer regulatory cooperation in the UK is also reflected in an updated memorandum of understanding between the ICO and the CMA. So updating the scope of that to reflect the scope of and the extent of cooperation across our ranges of functions, underpinning that as well with principles about providing each other with advice in relation to our respective functions, information sharing provisions, and also ongoing engagement in areas of mutual interest. And then more generally, it's also worth drawing attention to the DRCF, the Digital Regulation Cooperation Forum that we have in the UK, comprising the CMA, the ICO, plus Ofcom, and also the FCA, the Financial Conduct Authority as well. And that's been established to support a joined-up approach to digital regulation, and it's under that sort of umbrella of the DRCF that this work is being undertaken.
Tom, I'll tell you what, the joint statement I thought was really interesting. I know it mentions the Google Privacy Sandbox. Maybe you can just take a minute and then we can turn to Tanya after that.
Yeah, of course. So this gets a little complicated, so I'll try and keep things simple. But yeah, Privacy Sandbox is the name that Google's given to its proposals to remove third-party cookies and other functionality from the Chrome browser, and to replace them with a set of tools that are intended to be less privacy intrusive. So to briefly explain, cookies are these sort of small text files that are stored on users' computers, and third-party cookies, amongst other things, are building blocks for how digital advertising currently works. And the proposals raise questions that touch on both privacy and competition sort of issues. So privacy concerns have previously been raised about the current use of third-party cookies, for example, in the ICO's previous work on real-time bidding. And equally, from a competition point of view, the proposals could have significant impacts on publishers, on advertisers, and on other market participants. So it's really important that both of these angles, the competition and the privacy considerations, are taken into account. And as I'm sure people are aware, the CMA opened a Competition Act case back in January, and more recently has been consulting on a set of commitments proposed by Google. And if accepted, they provide a continuing basis for considering privacy as well as competition issues here. So involving the ICO and providing a platform for assessment of impact on data protection, on privacy, on user control, alongside obviously the CMA's interest in the competition angles. So I think the example of the Privacy Sandbox is a really good one, because it neatly illustrates both the interaction between competition and privacy issues that we're seeing, and also how, as UK regulators, we're working together to seek some of the solutions too.
Thank you. So Tanya, let me ask you. So Tom mentioned the issues that are at this intersection between data protection and competition. So from your standpoint, where do you see the potential for harm from data, and does this create scope for further policy intersections? How do you see this intersection?
Thanks, Lawrence, and also thanks for inviting me today. In a nutshell, I do see scope for further interactions, and I think in part that's driven by the role that data plays, particularly when we're talking about online. But let me start by just recapping on why it is that we talk so much about data these days, and I think there's sort of three dimensions to that observation. The first is that there's just a lot more data out there, and in parts that's because we're carrying around these connected devices that allows the collection of data across a range of activities, huge breadth, depth, speed with which this is done, and at really high frequency. So there's just a lot for us to analyze. Secondly, I think we're also getting better at analyzing that data, and that's in part because we have stronger computational facilities, but also because our analytics is becoming more performant. We can learn more from the data that's out there. And the third area, which I think is particularly important, is that we can leverage data in a more personalized way. And by that, I mean that we can observe activities of an individual and attribute them and aggregate them, and then analyze that behavior to better understand people's personal preferences, and then to tailor or target services accordingly. And really, as a baseline, that's great, right? It's allowed a lot of innovation, particularly online. We're seeing new innovative services like ride-hailing platforms, but also for us as consumers, it's allowed for us finding things that we like online much more easily, be it a video, be it a dress that you're looking after, or that you'd like to purchase. That said, the way that we're collecting and using data is also raising a range of policy questions, of which privacy, of course, is a very obvious one. And competition, I think, is an area that's particularly useful to pause on a little bit, I think. And I think there's two potential areas of interest here for competition. The first one is occasions where access to data can raise barriers to entry. and where that might undermine effective competition. And that can happen because there's economies of scale. So the more data you have, the better your service is. And that's what happens in search. If a company has access to a lot of search queries, that means it has a lot of click and query data, and that in turn allows it to offer really effective, relevant search results. But there can also be economies of scope, and that can be occasions where combining different data sets allow for better services. And here we can think of advertising, for example, where building a very detailed profile of what I like might help target advertising to me more effectively. And so a company that's able to know a lot about me by tracking me across different services might then be able to offer sort of a more targeted advertising service at me. Now, where those economies of scale and scope are very significant, that is where we might see some challenge to competition, and particularly if smaller players don't have access to data in the same way that incumbents might. And to the extent that that limits their ability to compete, well, what we might then see is that the incumbent can get to a position of market power or substantial market power, and that can be particularly problematic where that's entrenched. A second area where I think data is interesting for competition is where you might have a player or an incumbent that already has an entrenched position, but that can take actions to protect its sort of relative advantage in data. And I think Tom's example just now about sort of narrow interpretation or the wrong interpretation of privacy or data protection is a really good example of that. I think another example is something that's been brought up in the CMA Digital Advertising Market Study, is this idea that the way that we present choices to consumers on how they share data can sometimes get them to share more data than otherwise they might have. And if that's done by sort of an entrenched incumbent, well, then that allows them to collect a lot of data and sort of stay ahead. Another example can also be where there might be limitations on porting data between an incumbent and a rival service. That might raise barriers to switching. It also might limit the ability of rivals to kind of gain data from new consumers, and therefore again sort of facilitate the entrenchment of an incumbent's position. So now that we know data can sometimes be quite important for competition, I don't think it's a very long stretch to realize that where personal data is involved, that interaction between privacy and competition is very easily found. That said, I think there's a number of other policy areas where we might be concerned about the collection and the use of data, and which I think explains why we're seeing some of the wider interactions as well. And here I want to point to sort of a growing debate around the potential for personalization algorithms to lead to certain harms. And a good example of that is kind of the discussion around potential for echo chambers online. And that's that idea that services might service content that we like to keep us engaged. And maybe the most engaging content is content that confirms our views. And to the extent that means that we see less plurality of views online, that might be a concern if that raises issues of polarization, for example. Another example of that can be the use of personalization algorithms, which are really effective at spreading harmful content to people that are very vulnerable to it. And you can think here of self-harm content, for example, being targeted at teens. So again, if we think of some of those algorithms using personal data, that intersection between privacy on the one hand and issues of exposure to plurality or exposure to harmful content aren't really that far away. And on a finalizing note, if I can, I just want to take one moment to move away from data, actually, and just to point to the fact that I wouldn't be surprised if in the future we will start seeing interactions as well between competitions and other policy areas. And I think here the case of Parler is really interesting. So essentially, in a nutshell, Parler got kicked off of Amazon Cloud earlier this year, essentially because it was carrying content that was considered to be incitement to hate, so harmful content. And so what did Parler do? It took an antitrust case against Amazon, basically claiming that Amazon's reason for kicking Parler off was to protect its other customer called Twitter. And really what was happening in this setting was that by kicking Parler off, it was reducing competitive pressure on Twitter. Now, we can debate in this context whether that was a good antitrust claim, but I think the nut and bolts of it is that we're starting to see that interaction between competition and online content issues. And then the second, and I think very interesting example currently in the UK is follows the Cairn Cross review. And that was a piece of work where we were exploring the impact of online on the sustainability of news. And two of the issues that Cairn Cross review brought up was, on the one hand, the question whether a lack of competition in advertising might mean that, news providers might find it more difficult to monetize their content with advertising, but also whether big platforms like Google and Facebook have so much market power that they can use the content of news publishers without giving them a fair return. And what's interesting here is that, again, you're starting to see that intersection of policy areas, in this case, competition and media plurality, with the link being that a lack of competition might make it hard for news publishers to remain sustainable, and then in turn, the potential knock-on effects for sort of a plurality of voices in your media landscape.
But, Tanya, competition analysis is challenging enough by itself, but now we have this privacy intersection. You've raised the media plurality and harmful content as additional intersections. How are the competition agencies going to account for all the different dimensions and all the different and potentially conflicting objectives? Doesn't sound like an easy task.
Yeah, not at all. I think that's right, Lawrence. And maybe what I can try and do is I can take some of the observations of Tom and myself just now and try and shape that in a little bit of a framework, or some areas where as competition authorities over time, we might find that we need to think about these other policy areas. And the first observation is that there might be times where competition issues exacerbate harms in other policy areas like privacy. And as an economist, I think one way in which we can try and capture that is to think about price and quality in a very broad sense of the word. So let's say we think about data as a way for us to pay to access online services which otherwise are free. Well, in that case, if there isn't enough competition, then prices might be too high, or in other words, we might give up too much data than we might have to do if there was more competition. Another example could, for example, be an online news aggregator that doesn't face a lot of competition. Well, it might not have an incentive to then moderate out fake news. And in this sense, what we can think of is this service as offering a low quality product. Essentially, it's exposing people to false information. So I think, first of all, where sort of competition can exacerbate harms, I think thinking through how competition lead to harms is something that as competition authorities we could consider doing. Second, I think there might be cases where an issue in another policy area, like privacy, is at the source of some of the market power issues that are being identified by a competition authority. And I think Tom's example earlier about that interpretation of data protection law that favors the incumbent is a really good example of that. If the Parler case was a real good argument, then that would be another example of that. So really what we're saying here is, as a competition authority, to understand the source of the issue, you might need to understand what's happening in other policy areas. And finally, I think there will be occasions where, as a competition authority, the design of an effective and proportionate remedy might require you to understand other policy areas. And let me give you an example of that. So in the antitrust or sort of the competition debate around online platforms and market power, one of the potential remedies that sometimes get batted around is consumer-led data mobility remedies. So the idea that it's easier for a user to port your data from one service to the other, that can reduce barriers to switching, that can lead to more data for small rivals, and therefore that can help sort of facilitate that competition. Now, if people are worried about privacy, then you might have a beautiful consumer mobility remedy, but no one might use it. So really you need to design it quite carefully so people trust it and then actually use it for it to be effective. It can also go the total opposite way, where people might end up using the consumer mobility remedy without really realizing what's happening with their data and the implications of that data sort of spreading more widely, as Tom mentioned earlier. And in those cases, your remedy might have negative unintended consequences in the context of privacy. So really what we're saying here is that for a competition authority, it might sometimes be necessary to understand other policy areas like privacy to make sure that remedies are designed well. Now, competition policy, though, is just that, right? It's sort of focusing on addressing competition issues. And I think what that means in practice is that we need to be humble as well and accept that sometimes consumer harms can't be addressed through competition tools. And really what we should be using is other tools. There are very competitive markets that lead to bad outcomes. And quite often that's because consumers can't really make choices effectively in a way to discipline companies to remove harm. So let's take the example of fake news again. Sometimes people might just not have the information they need to understand they're being exposed to fake news and therefore wouldn't be able to vote with their feet to get companies to compete and remove that kind of fake information. And what you need in those cases is kind of a regulatory tool alongside of competition so that you can resolve issues. And the point I sort of want to finish on is that I think that's actually a really important observation and one of the reasons why we have the DRCF. And that is because sometimes there can be a perception or an argument that competition can worsen things like privacy harms or online content harms. And really what I think we need to be careful of as regulators is that we don't necessarily make it that mean that competition comes second. But really what I think we ought to be doing as regulators is to, in those cases, carefully understand why competition might be leading to worse outcomes. And to then think about whether we have other regulatory tools like GDPR, privacy protection, that we can complement to competition policy so we can almost get the best of both worlds.
Before we turn to Jerry, let me just quickly ask you, but when we think about the remedies or the regulatory tools, what's the current thinking on, do you apply these tools ex post, or is this something that you think the authorities are going to have to start thinking about applying these tools ex ante?
Yeah, so very topical question. I think there's quite a lively debate currently on whether we should be regulating the largest online platforms ex ante. And the UK government has actually published its consultation on that on Tuesday. And basically, it's about regulating those online platforms that have substantial market power sort of in an entrenched way. And the objective is twofold. It's to kind of prescribe the behavior for those companies so that they can't exploit that market power or use it to undermine competition in related markets, and really do that in a forward-looking way, so before harm arises. A second objective is essentially to potentially foresee pro-competitive interventions and try and address the market power in the first place. And what's interesting about the consultation is that it's very much clear that the objective of the regulation is promoting competition. However, government has recognized these links with the wider privacy and plurality issues. And it does that in three ways. First of all, it sort of creates the expectation that the digital regulator will look to create coherence with other regulatory frameworks. Second, it's asking a question in its consultation on whether that regulator should have supplementary duties, which would give it some discretion to be able to take into account those wider policy objectives where relevant. And thirdly, it's considering the potential for information sharing between regulatory authorities to allow for that to work well, and potentially even for a duty on the digital regulator to consult with other regulators like the ICO or Ofcom. And where we're ultimately going to end up, that's for government and parliament to decide. But I think there's sort of two areas of discussion which I think will be particularly interesting in the follow-up to that. I think the first one will be which supplementary duties will ultimately be added, if any. Is it really about privacy and plurality, or could it potentially go further and include things like harmful online content? And that's particularly interesting for someone like us at Ofcom, because that could then potentially require that kind of regulatory interaction and relationship between Ofcom and the digital regulator, the same way that that's already happening between the ICO and the CMA currently. And secondly, I suppose there might be a little bit of a debate on how the digital regulator should then reflect those additional duties. And I think for me, it comes down to three areas. I think first of all, It might need to think more broadly to identify all the harms from competition issues, and that might help it prioritize. Second, it might need to understand other policy areas to really understand sources of harm and address them effectively. And finally, I think it might have to think about wider policy issues to make sure its remedies are effective and sort of manage unintended consequences.
Okay, so Jerry, let's turn to you. So Tom and Tanya have raised some interesting comments on the intersection, and it seems to me it's a little bit too early to talk about litigation, but I'll ask you that. But how do you see all this playing out practically, especially in the courts?
Well, I think, first of all, again, thank you, Lawrence, for agreeing to chair today's session. I think there are some really interesting legal issues that are going to arise in relation to the interaction between the data protection and privacy regulatory framework and the competition analysis and competition framework. And particularly where you're talking about regulators thinking about ex-ante remedies, which might mandate certain types of data processing or indeed have data carves out, prevent certain types of data being processed. In the usual regulatory litigation context, you will have courts which are giving a fairly high degree of deference to the economic judgment of regulators, whether that's the Competition Appeal Tribunal in the UK or the European Court of Justice in relation to the Commission or in the US courts. But where you've got an economic regulator who is doing something in relation to data, there are a whole set of additional tests and standards which are going to have to be grappled with, which the courts will have to apply, because you're not just then considering consumer welfare as a sort of collective good or effective competition as a collective good. You might be doing something which is actually interfering with individual fundamental rights of data subjects. And so there are a whole series of additional hoops that the regulators will have to go through, that courts will have to consider if ex ante or even ex post remedies engaging data privacy are start to become commonplace. So, I mean, just to give you some examples, under Article 6 of the GDPR, there has to be a lawful basis for any data processing. So if a regulator is going to mandate a certain type of data processing, whether it's data sharing within a particular sector or treating some sort of data as an essential facility to which access has to be given, for example, what's the lawful basis for that going to be? Is it to comply with the legal obligation? Is it in the public interest? Is it for some other legitimate interests? And all of those, one of those will have to apply, and all of them have a necessity and proportionality assessment which goes alongside them. So not just an exercise of regulatory judgment, but a fundamental rights analysis. So are you interfering with the rights to the least extent possible? Is there a rational connection between what you're doing and the connection with the rights? So there's plainly lots of scope for argument and legal challenge in relation to any sort of regulatory remedy. And then, for example, there's a prohibition in the GDPR against processing data for a different purpose than that for which it was originally collected, unless you're going to base that on consent. So if, again, a regulated undertaking is going to be required to process data in a particular way as a result of a code of conduct or some other kind of ex-ante remedy, there are a whole series of issues there that arise about the consent of data subjects. Have they been notified? Could they reasonably have expected that the data might be used in this way, that it might be subject to some kind of regulatory remedy in that way? What are the objectives being pursued? Again, can you justify them using a fundamental rights analysis? And it will be a more intrusive legal standard that applies. And a third good example of this, which is one that has caused problems in exactly this sort of context, is the right to object, that is now a specific right in EU data protection law. You have the right as an individual to object to being profiled or to receiving data direct marketing or having your data used for the purposes of direct marketing. And it's in the public domain that a few years ago, the Competition and Market Authorities was looking into the energy sector. They thought it would be a good idea to have a disengaged customer database. So you have a whole series of gas and electricity customers who are very sticky. They never switch. They're sitting on the same rubbish tariff that they've been on for however long. And in order to try and get some churn in those customers, the CMA and then Ofgem started looking into the possibility of having a form of database whereby these disengaged customers' details would be uploaded onto the database by the suppliers. Then competitors could approach them in some way and say, look, you're on a terrible tariff, you really ought to be switching, you could save money in all this kind of way. And Ofgem looked at that for a number of years. There were consultations on it, and ultimately it had to drop the idea, and it did drop the idea, in particular because some of the data privacy issues were just too difficult to deal with. For example, as some of the energy companies said, we have lots of customers who have told us they don't even want to receive marketing from us. We can't lawfully process their data to market to them. How can it be right in that context that a regulator could mandate that they should receive marketing from some of our competitors? So those are, I think, some of the difficult interactions that will arise once you start using competition law in an area that affects data privacy.
But Jerry, the example you just gave, and if you start describing data protection in terms of rights, that just, it seems to me that just tees up an important issue for the courts. Are they going to be forced to make a trade-off between data protection over competition? And can they really do that? Or how, if it feels like we're forcing the courts to make a choice here.
Well, they can certainly do that. I mean, that's the sort of balancing exercise that the courts do all the time in relation to individual rights. So commonly you have one individual right which is in conflict with another, or you'll have an individual right which has to be interfered with for some collective public goods. So, but I think it hasn't yet really happened that the courts, either in the US or in the EU or the UK, have had to grapple directly with the question of whether the public interest in competition or in effective competition can override individual privacy rights, or the extent to which it can justify an interference with them. And I think, I mean, it may be that the UK and the US courts are probably likely to take quite a regulator-friendly approach to that. But one of the key decision makers here is going to be the European Court of Justice, and that is a court which is a privacy-obsessed court. I mean, it's some of its most important landmark judgments in the last 10 years have been on data privacy. It's a number of the judges on that court treat privacy as their sort of #1 priority that they care about. And so if you have the Commission, the European Commission, engaging in some of these kind of remedies that we've been talking about, or some of these market interventions, it may well be that court which has to grapple with some of these issues. Can the collective interest in effective competition trump individual privacy rights, or to what extent can regulatory judgment justify some sort of intervention which isn't totally consistent with GDPR? And it's, having had a lot of experience of arguing privacy cases in that court, I think that will be quite a challenging court for the European Commission to go into and have to defend its decisions if it's, for example, mandating data sharing without consumer consent. There is, I mean, in a way, there's a sort of inherent tension, because the way that privacy law is developed, particularly with the GDPR, is that it treats data as a sort of very valuable asset which has to be protected, and it shouldn't be processed more than it needs to be. It shouldn't be shared. It has to be subject to all kinds of protections. And then if you're in a context where in a competition law analysis you're treating that same data set as something that maybe amounts to a barrier to entry, may even be an essential facility in some contexts, where with competition law would suggest we need to provide access more widely to this data set, then that's quite a difficult tension to see it being worked out when you have the GDPR framework on the one hand and traditional competition analyses on the other. But I mean, regulators and courts will have to grapple with those issues and get used to them. And the truth is, there are ways in which the frameworks could certainly work effectively. I mean, one example, I was just looking at it earlier today, is Article 40 of the GDPR, where there's a particular provision in the GDPR and in the UK GDPR which envisages codes of conduct for particular sectors, and envisages sectors coming together, drawing up a code of conduct about how data is to be shared and processed in that sector, how it should be done fairly and transparently. You can then have the ICO as the regulator accredit an industry body to monitor compliance with it. I had a quick look at the ICO's website, and there aren't any accredited codes of conduct yet, as far as I can see. But I can see that would provide a mechanism which is there on the face of the GDPR framework, whereby you could have a sort of code of conduct that the competition regulators could get involved with as well, which might well then be signed off and could be overseen by the privacy regulators.
I want to get into a conversation with everyone on how we even define the harms and measure it. But before we do that, Jerry, I just have to ask you, I know on competition class actions, they're being brought in the UK and across Europe. How do you see class actions developing here in cases involving competition data privacy?
Well, in Europe, there haven't been any significant ones yet, in the EU rather. In the UK, we're all waiting with bated breath for the judgment of the UK Supreme Court in Lloyd and Google. So that hearing took place in April this year. And that effectively, I mean, the key issue there that the Supreme Court will decide is whether the current civil procedure rules in the UK allow opt-out class actions in the data protection sphere. The Court of Appeal said that they did, and so there are a huge range of litigation funders, lawyers who are ready to pull the trigger on well-funded opt-out class actions. But the Supreme Court may say that they don't. If the Supreme Court says that the current rules don't allow that, then the UK will be a jurisdiction where there is no effective means for opt-out class actions to enforce data privacy rights and seek damages, which will mean presumably that regulatory enforcement becomes all the more important in this context. And on the other hand, if the Supreme Court says, yes, you can do it, then, I mean, as we know from the competition sphere, private enforcement can have, in some cases, an even more effective deterrent effect on unlawful conduct than regulatory enforcement. So I think that Supreme Court judgment will make, I mean, it will really change the landscape one way or the other over the next few years.
Okay, look forward to that. All right, so let's we can do this many ways. Let's have a conversation. You know, a lot of complex issues here, and let's think about consumer harm. You know, in antitrust cases, competition cases, it seems like it's more well defined, but in this intersection, it seems really, with all the multiple dimensions, seems really complicated. So let's just go around the room here. How do you think about articulating the harms and measuring consumer harms? Tom, you want to kick us off?
Yeah, sure. Thank you. So I suppose a couple of thoughts on that. I mean, Tanya's already mentioned the sort of the idea of, or perhaps the leading idea of how to incorporate privacy thinking into competition, and thinking about, you know, privacy as quality, as a sort of non-price dimension of competition. But we know that, yeah, measuring those non-price effects can be a challenging thing to do. And I think, yeah, particularly when it comes to privacy and data protection, you know, harms, it's also the case that measuring, and actually sometimes even just identifying, you know, the harms is challenging too. There's a number of sort of things interacting here, I think. Firstly, there's something about the nature of the harms, the nature of sort of data protection harms. Sometimes, yeah, they're you know, readily identifiable, even quantifiable. Perhaps, you know, financial harm, you know, resulting from fraud and, you know, the loss of a certain amount of money. But, you know, other aspects of harm, perhaps even harm resulting from the same event, you know, maybe distress or loss of trust, are intangible and much more challenging to identify or to quantify. And of course, the identification of harm, you know, even in itself can be challenging when it's not apparent, you know, to the data subject. Perhaps when there's you know, invisible processing, when it's not apparent to them that their data is being processed. And then I think as well, you know, the harms are often, or the harms are, you know, risk-based. They're often intertemporal as well. So, you know, individuals might struggle to assess the likelihood of harm occurring. You know, maybe there's incomplete information or behavioral biases, you know, demand side sort of distortions. And then that can be compounded as well by the intertemporal nature of privacy harms, where, you know, harm might occur a long time after, you know, data is shared, for example. So yes, you can have a situation where, you know, as an individual thinking, well, do I want to provide my data to, you know, this company or that company? The trade-off that I'm facing is a really difficult one to get a handle on. I can have, you know, perhaps something tangible now, and what I'm weighing that up against is, you know, the possibility at some you know, perhaps undefined point in the future of, you know, some harm perhaps occurring, you know, and I may not even be aware of it when it does. So that's a really difficult thing for individuals to grapple with, and it's equally a difficult thing for you know, for regulators and others to grapple with. And then yeah, I suppose it doesn't even stop then, because, you know, harms can be, or data protection and privacy harms can be really quite diffuse. You know, harm to any individual, you know, might not be terribly substantive, but Tanya, for example, was talking about sort of trust and, you know, engagement in, you know, maybe online services. You know, there might be very significant societal harms that can, you know, where you know, individual harms can aggregate up and cause significant harm at a societal level. And that's, of course, even before you get to the fact that, well, harms can vary by data subject. You know, privacy harms can vary by data subjects. Individuals, you know, value their privacy to different extents, and, you know, different events might impact on, you know, individuals in different ways depending on their circumstances. And then I suppose to sort of come back round to some of the sort of economic points as well, you know, some of these harms can be difficult to avoid. You know, if there are circumstances in the market, you know, market power, barriers to switching, perhaps, you know, even the most, you know, informed consumer may not be able to, you know, discipline providers, for example, by being able to switch to alternatives. So yeah, it's a really interesting area. It's an area where certainly the ICO, you know, is doing some thinking, and there's some interesting academic research in this area as well.
And Tanya, how do you think about this?
Yeah, I think from a sort of harm perspective, don't have much to add what Thomas to say, but maybe what's important for us as regulators is to have sort of good, solid frameworks to try and help us cut through some of this complexity. And I think we can do that in a couple of steps. I think the first step is sort of the moment where you might spot a particular harm. And I think at that point, the first question should be, what is at the source of that harm? Is it a competition issue, or is it something wider than that? And that goes back to my point of earlier, which is competition the right tool to use, or is there another regulatory lever that we sort of better placed to intervene at this stage? So let's say at this gating question, you've decided competition is the right way to go. Then I think the next step is what I would call identifying your theories of harm. So you've identified your competition issue, and then it's sort of trying to systematically list what the harms are that you think can follow from that competition issue. And here I think Gary's point becomes extremely interesting, I think, because as a regulator, what you have a duty to consider, I suppose, in part is determine what's in legislation. And I'm sure Gary can comment on that much better than I ever could as an economist. But that seems to be at the heart of some of the questions that the UK government is consulting on currently as part of the anticipated ex-ante regime. And then there's the third step, and that's the step when you get to remedies. And here I think what's important for us as regulators is that we think through very carefully what all the impacts are of our interventions. And that's not just in terms of tackling the kind of issue at hand, let's say a lack of competition, but also the potential for any unintended consequences in other policy areas like privacy, and particularly the possibility of worsening those harms. And that's really important because hopefully in most cases, we'll be able to manage that tension just by shaping the remedy in a more intelligent way. To the extent that that's not possible, I think this kind of framework and approach allows us to very clearly set out what the trade-offs are, and be transparent as a regulator about how we made those trade-offs. And I think that's important, because that means that if it does come to the point where you're in a court, you then hopefully over time will get decisions that start clarifying how to balance those objectives, and whether as a regulator that's done correctly. Of course, again, I suppose that might depend on what legal standard you have of review of your decisions, but potentially that could be one dimension that could help with this question.
Right. Well, Tanya, I mean, that's so right. You mentioned impact. You mentioned you know, a lot of these issues we're going to see ultimately clarifying decisions, but you know, I can also imagine a lot of businesses are looking for guidance. So at some level, help articulating the harms and how and the evidence one would look at is important for businesses. And it's probably hard to do now, but you know, for in terms of guidance and helping businesses make decisions, especially with ex-ante regulation, you know, that's I can see that as being a big challenge and topic for the you know, for Ofcom and the ICO also.
Yeah,
Hey,
definitely. And if I can quickly respond to that, Lawrence, I think that's a really good point. And I think maybe what's interesting is to just refer back to what Tom was saying earlier, and which is we're probably going to be taking this to a large extent case by case, at least under the UK framework. And I know the EU proposals on the ex-ante regime seem to be a bit more rules-based, and maybe there's less of a case by case there, but at least from the UK perspective, I would imagine that we'd work through that with the companies that are subject to the regulation to help kind of build that clarity. I think a second thing what we might need to deal with is observe and learn over time on what works and what doesn't, and kind of accepting that we might need to iterate over this to get to the right place. And that sometimes then raises challenging questions around proportionality as well in and of itself, but I think that's potentially a reality here.
and Jerry, how do you see this from your standpoint?
I mean, I think I agree with what Tom and Tanya have said. I mean, I think the really interesting stuff is the stuff that Tom was mentioning about wider societal harms in relation to data, because it's so hard on an individual level. I mean, people have so many different attitudes about their data. Some people like to be profiled because they like to go onto Amazon and have great suggestions provided to them, or when they go on to do their supermarket shopping, they want a particular type of tomatoes that they've bought in the past, rather than scrolling through 300 different types. And some people, as we know, walk around with tinfoil hats because they think they're being profiled all the time. So I think there does need to be more analysis, and I think there is some interesting academic analysis going on around those wider societal harms. And actually, in the Lloyd and Google hearing in the Supreme Court, we had some discussion about that, about the fact, because one of the issues there is Google's essentially saying that there's no evidence that any of the consumers who had a cookie unlawfully placed on the Safari browser on their iPhone over a period of a number of years actually suffered any distress or harm. And certainly none of the 4 million odd consumers who are being represented in that claim. And so one of the arguments is that the court needs to analyse the framework and the concept of damage to consumers in a much wider way, looking at the overall damage that arises when large companies intentionally and unlawfully breach data protection rights.
Okay, so just a couple of follow-ups. So Tanya, I think Tanya used the term unintended consequences. Tom and Jerry, do you see unintended consequences of let's see, of say, if there's an emphasis on data protection, for example, what are some of the policy issues that you see coming up that might fall in that category of consequences, unintended consequences, or you know, consequences that might be more predictable?
Tom, do you want to go first?
Thank you. Yeah, no, absolutely. I think you know, really, it's around the issues that we spoke about at the beginning, where those tensions can arise. They're obviously the areas that have already been identified where where unintended consequences could occur. But I think the thing that I would focus on is the fact that as UK regulators we are working together. Well, look, we're here having this conversation, trying to explore these issues and understand the different points of view, the different objectives of the different regulatory regimes, to understand how they interact, so that we can make good policy and avoid those unintended consequences.
What about you, Jerry?
Well, the only thing I would add is that, I mean, obviously, because personal data is something which is subject to a whole bunch of additional restrictions, one of the things I think the regulators need to be wary of and look out for is the sort of perverse incentive that companies might have actually to be storing customer data in a way that is personal data rather than pseudonymized or anonymized or something that would fall outside the data protection regime. So, I mean, if a company thinks that it's going to be forced to hand over or to share one of its data assets, it might well be incentivized to retain a much more granular level of data than it otherwise would, just for its ordinary business purposes. So they could, I think, we'll need to be careful that more competition enforcement in the data sphere doesn't actually lead to companies processing and storing and collecting more personal data than they otherwise would, because they think that gives them some additional protection.
I think, Jerry, so you mean if companies knew that the data protection enforcement was going to be, or might lead to more sharing, then they may actually collect more personalized data, so that they would not, which would be less likely to be forced.
Yeah, I mean, if you have a data set which is more extensive, more intrusive, includes special category data relating to health, for example, it will be much more difficult for a regulator to say that that has to be shared or has to be processed in a particular way, because there are additional legal constraints around how it can be used.
Right. Interesting. Okay. We have a couple of minutes left, and I have to say I've enjoyed this conversation and the conversation with this. So maybe we can just go around the room and just get everyone's final thoughts. So maybe 30 seconds of what you think the key takeaways here for you, and what to look out for going forward. But I'll tell you what, we'll do it the other way around. Since Tom started, we'll start with Jerry, and then Tanya, and then Tom. How's that?
Okay, well, I mean, from a lawyer's perspective, I think there are going to be all kinds of interesting issues that have to be litigated, because the GDPR is still a relatively new regime, privacy regimes all around the world. I'm speaking to you from Australia. There's going to be a new updated privacy regime in Australia. So there are lots of new legal issues arising there, and then to overlay that with competition regimes, I think there's some really interesting issues for regulators to grapple with, and undoubtedly lots of scope for regulated businesses to be challenging regulatory decisions, to use data protection and fundamental rights analysis about their customers to challenge interventions. So I think that will keep all of us very busy for the next few years. All
right, Tanya.
I think for me, the first point is that I think we're going to be talking about these intersections a lot more in the future, and not just privacy and competition, but more widely. The second would be, I think, as regulators will do well having clear frameworks to step through and understand harm and how to address it, and be comprehensive in assessing unintended consequences and trying to tackle them. And really, the best way to achieve that is regulatory dialogue, not just between different regulatory authorities, but also authorities and the companies they'll be regulating.
All right, Tom.
Thank you. I'm not sure there's an awful lot left for me to say because of those two previous sets of comments. But no, absolutely fascinating discussion. I think, yeah, agree with what's been said. And from my point of view, yeah, going back to the beginning, yeah, emphasising the synergies that exist, between the competition and the data protection and privacy regimes, and yeah, recognizing that while there might be potential tensions, the way to overcome them is to work together collaboratively as regulators, understand each other's point of views, and yeah, continue exactly this sort of discussion.
All right. Well, before I turn this over to Pam Weiner to close, hey, I just want to personally thank you, Tanya, Jerry, and Tom for the conversation today and the conversations we've had. I've really enjoyed it, and I hope we can do this again. But thank you so much. And for everyone in the audience, thank you for joining today. I hope you'll help me thank the panelists for their thoughts today also. So thank you for that. Pam, you want to close us out?
Yes, thank you to our panelists today. One thing to mention is that the opinions expressed today in this webinar were solely of the participants, of the presenters, and they do not reflect the opinions and beliefs of their organizations or affiliates unless they expressed it explicitly. And again, thank you for joining us today. We look forward to seeing you next Thursday at 3 p.m. for our final session in the series, Abuse of Dominance. Once you leave today's webinar, a brief survey will appear in your browser. We appreciate any feedback you have to offer on behalf of Moncton Chambers and your economic consulting. Thank you for joining us and enjoy the rest of your day.